A gun-free zone is simply a start shooting zone, renamed. You and I know that, but as a practicing criminal defense attorney and former state prosecutor, I can never legally advise clients to break any law. So no need to skip down, I won't be doing that here. Then what the heck is going on? Well, I want to take a moment to talk to you about some of the trade-offs and consequences of carrying in a gun-free zone. First, the obvious. Laws change with place and time. It is impossible for me to address every combination of place, time, and person in one article. Visit the USCCA's Concealed Carry Reciprocity Map and Gun Laws by State Map to learn more about your specific situation. What I really want to do is to get people thinking about their own scenarios and analyzing to make their own decisions. The places that most often come up when referring to gun-free zones are United States Postal Service properties, schools, and private posted property. Let's take a look at these in turn. Post offices are federally regulated. This means that if you run into trouble in one, you are in federal trouble. This may be better than your local courts, or it may be worse. But it's generally always a big deal. The quirk to the Postal Service issue is that it includes the grounds, such as the parking lot. So even having a firearm in your glove box in a post office parking lot can be punished as a felony with prison time and stiff fines. Of course, if you are comporting with laws, you can mail a long arm lawfully from a post office, but a loaded concealed carry sidearm is different. Schools are a maze of both state and federal issues. The Federal Gun-Free School Act of 1990 applies to public, private, and religious schools at the elementary through high school level and all non-private property within 1,000 feet. Universities are excluded, but basically, everything within 1,000 feet of a school is in play for this law, provided you are not on private property. In other words, if you are visiting a friend with a home next to a school, it is fine to safely clean that M1 Garand in the backyard. Just don't carry it on the sidewalk or any other place that's within 1,000 feet of the school and not private property. Keep in mind that there is a difference between the school itself, the grounds, and the 1,000-foot magical buffer that surrounds it. Now, it gets tricky. Both the federal law and many states carve out exceptions. For example, if you are off school grounds but within 1,000 feet of a school, you can possess a firearm on public property. That is, as long as you are a concealed carry license holder, the firearm is unloaded and contained within a locked container or a locked firearms rack that is on a motor vehicle. The firearm is possessed by an individual for use in a school-approved program, or the individual is crossing school grounds with permission of the school to reach a public or private destination, and the firearm is unloaded. There's a mouthful. Carrying without any of the previously mentioned conditions is considered a felony, to include prison time and, again, stiff fines. These are, in my experience, most often prosecuted at the state level. The last area often asked about is posted private property, such as the mall or some other business. Maybe it is an apartment building, if it is legal to post those in your jurisdiction. The laws on this vary widely from state to state. In some states, such as my home state of Wisconsin, if a business discovers that you are carrying where you ought not be, it cannot automatically call to have you arrested. Instead, you must be given a warning to leave. Now, should you disregard that warning, you may face arrest and subsequent charges. Penalties here range from non-criminal tickets all the way to felonies. This can vary greatly based on locale, so it is critical that you learn your laws. A few odds and ends. Some states have laws out there about notifying law enforcement automatically upon contact, such as a traffic stop, if you are in possession of a firearm. Also, in some cities or states, places of worship are always off limits, along with courthouses, police stations, jails, etc. Finally, keep in mind the government needs to prove that you intended or knew that you were carrying in a prohibited place most often. So in fact, almost always, it does not need to prove that you knew that you were breaking the law. Your mere presence with your weapon in a location is considered proof enough when combined with proper posting. At the very least, a prosecutor may feel like he or she has enough to charge you and let a jury decide. We've all heard it is better to be judged by 12 than carried by 6. Or, if I have to use my gun in a gun-free zone, the presence of that gun is the least of my problems. I get it. But as a defense attorney, I can assure you that the consequences for being caught can be severe. In the end, each individual is going to make his or her own choice. And I'm not trying to get people to do anything more than pause, introspect, and think.